What's up, everybody? Welcome back into another episode of The Lawyer You Know. We are breaking down day 20 of the Karen Read trial, the last day this week. We had a really fun expert witness to me, pretty incredible academic background and a literal brain surgeon. Like when people say it's not brain surgery, well, that's what this guy does, which I found to be very interesting. We had some juror issues in the morning we're going to talk about and answer your questions and find out what Karen Read had to say about it at the end of the day. And of course, another witness with a bunch of numbers trying to tell us something that I didn't really understand until we got the best demonstrative aid I have seen in this trial to date. Hit that like button. Let's get to it. So by the way, yeah, we were supposed to start at 4:30 and then kicked it to 4:40, but then I was able to get here now. So here we are, right? Keep you guys on your toes. Always be around and make sure you're subscribed and have that reminder bell hit so you can know when we go live to talk about this case and so many others. And by the way, there's 5 days off of this trial, but don't worry, because I think we're going to be talking Koberger tomorrow. So make sure you hit the reminder bell so you don't miss out on that. And then something very special for you Friday. And of course, this weekend or Monday, we'll be dropping the podcast with my dad to get his thoughts. Yes, Ashley, that's a really great point. There's a time variance that Mr. Burgess can explain with his Bachelor of General Studies degree from the University of Alabama, Birmingham. Okay, enough of that, because we've got some real credentials to talk about today that I'm excited about. It's much more like the witnesses we have in my trials, and not just my witnesses, right? A lot of the defense witnesses in the cases that I try have Ivy League credentials, are brain surgeons, neurospine surgeons, orthopedic surgeons. So to me, it was fun. And it really is a good example of how you deal with it on cross. And I'm going to talk a lot about the lawyer strategy on how you cross-examine a witness. I'm not going to say this for Mr. Alessi because of how smart he is, but for myself, how do I cross-examine a witness that is clearly smarter than me, is an expert in the field that we are talking about? But guess what? I'm an expert question asker, and I know the answers to my own questions, right? So we're going to talk about how that works and what he did and how he exhibited that today. Points he decided not to go in on and why. Will they still be able to argue them? And then why did he pick the points to go in on that he did? And what was he trying to prove with the questions that he asked? We're going to watch the entire cross of that. So we started the day with the judge stopping everything, sending everybody out of the courtroom, and individually voir direing the jury. Each individual juror. It can really only be one of a few things for this happening. A juror heard something, said something, somebody said a juror said something or heard something, or there was something obvious in the courtroom that could have affected multiple jurors. So you have to individually question, did you hear this? Did you see this? Are you doing this? Are you seeing somebody else doing this? Is this affecting you? Has this affected your ability to be impartial? Have you seen something? Has somebody posted something on social media? Whatever it may be, right? Really can only be those issues that specifically deal with the jurors. It's not one juror is sick or one juror is now saying they want to leave. It's nothing like that, right? I wouldn't think. Let's hear what the judge says, which we'll see what kind of indication it gives us. And then we will read what Karen Read had to say after court today from a trusted source.
I still have a couple of questions for you. Were you able to follow the instructions and refrain from doing any independent research or investigation into this case? And we've discussed the other two questions, but I do need to stress for you that it's very, very important that no one discuss this case. Don't let anyone talk to you about the case.
So that's something I've noticed more, and I don't know. I don't always listen to the announcements Canoni makes daily, but don't let anyone talk to you about this case. And we're going to listen to what she says at the end of the day today. And it seems to me like that might be part of the issue, is somebody talking to a juror. Did a juror hear something or see something they shouldn't have? That's kind of an indication of what I'm getting, but we're never going to get the actual truth, at least not during the trial. Maybe afterwards we will learn. Also, from what I heard, because there's somebody in the courtroom that was actually texting or DMing me today, which was kind of fun. Not a lawyer on any team or anything like that, but and there were some reports that jurors had switched chairs. This person said the jurors didn't move chairs. So I don't know if it's true or not that the jurors moved chairs, but it seems confirmed that no jurors were struck no jurors were lost, which we're on day 20 and we're still 18 for 18. That gives me a heck of a lot of confidence that we are going to be able to get through this trial with a jury of 12 who is going to be able to deliberate and make a decision. Let's listen to the rest of Canoni's comments here.
Comments about the case. You've seen how hard the lawyers have worked to pull this case together for you, and everybody's given it so much time. So please, let's make sure that we follow that. That means each other. So with that, I know we're late getting started. We're going to take an abbreviated lunch today, only 30 minutes.
And that includes each other. So did one of them say something about the case that turned out to not be a big deal, but in abundance of caution, we talked through, oh man, can you believe what that taillight looks like? Some juror says that and another juror hears. She's like, that includes you guys. Don't talk about the case, including to each other. That to me is important. And that to me is something that I'm glad they are making sure the jury understands it. Okay. Now let's get to Dr. Isaac Wolf. Literally a brain surgeon. One of my favorite witnesses of this trial so far. I am probably biased. I love doing the medical experts in my trials. And he is literally a brain surgeon. He's an active neurosurgeon, pediatric and adults. He did 2 brain surgeries yesterday. He's got 4 tomorrow. He's got 4 on Friday. It's like, does it get any better than that? It's like, I was doing brain surgery yesterday. I'm going to do brain surgery tomorrow. I'm here testifying today. It's like, wow. Well, yes, actually it does get better than that, because with this witness, Attorney Hank Brennan did decide to go into his educational background, which I think was probably a smart idea, because you know what that educational background is? Yale Medical School. But it gets better. Summa cum laude. How about that? I mean, now that is an expert. And he's like, this forensic testifying stuff is only less than 1% of my income. And people are like, well, why would they call somebody like this? How would you find somebody like this that's not even a testifying expert? Is it better? Is it worse? Guess what? You don't have to be a forensic expert and focus in on testifying as a large part of your job or income to be an expert. We have had friends who own air conditioning companies, whose dad owns the air conditioning company, who's worked there since he was 15 years old for 30 years, who's been an expert on a premises case that dealt with a faulty air conditioner and what they did right, what they did wrong. No college degree, by the way, in case you were wondering, which we talked about. We kind of loved it. We owned it. We're like, you don't even have a college degree, sir. No. I was an apprentice. I learned how to do this. School of the hard knocks, right? So you don't have to be a hired gun type of expert to be an expert. Usually it makes it better. Usually we like that. It's like that makes them even less biased. They don't care, right? Okay. So he talks about John O'Keefe's injury. It's a classic blunt trauma injury. This is what happens when soft tissue hits the solid ground. And we're going to get to a couple of his opinions and the way that he describes them, because I think it's interesting for both sides. So let's take a listen to a little clip here.
This room.
I want to take a step back at the beginning. You said that this laceration on the back of his head was caused by a fall. Could this be caused by a fall landing on hard ground?
Yes. I mean, like I said, it's a classic blunt trauma laceration.
Do you have an opinion to it?
So it could be caused by a fall backwards onto hard ground. And I know the defense hasn't gone with that theory full bore, like maybe he tripped and fell. But I thought with this witness's testimony, he gave them quite a bit for that. He gave them quite a bit for that theory of reasonable doubt. Maybe she dropped him off and he just slipped and fell, tripped and fell. But it gets even better for the defense with that. Now, the Commonwealth wants to get this guy to say that because they want to make sure that the jury hears it didn't have to be a ridge or an edge of how he hit his head. Somebody's saying, I'm cutting in and out. Let me know if that's correct. So that's also really important to one of the defense's theories. Does it have to be a ridge or an edge to cause this injury? Pretty clearly from this witness, it does not. And that was, I think important for the Commonwealth.
A reasonable degree of medical certainty whether this injury, the laceration and the basal fracture, was caused by Mr. O'Keefe falling backwards on the ground.
My opinion is that that's what caused his whole injury.
The pattern of the laceration, do you have an opinion whether that is consistent with hitting the cold, hard ground?
Objection, Your Honor. Can we have sidebar on that, please?
So I'm sustaining the objection, so no sidebar.
Your Honor.
He's like, okay, no need.
Do you have an opinion, doctor, about whether that laceration on the back of his head was caused by a particular movement?
Well, the only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into his base of his skull.
Would that type of laceration require Mr. O'Keefe to have hit a line type or a ridge type object?
A rich type of object?
Yes.
No, I mean, like I said, the tearing of the skin in that fashion, you could look it up, would be just a classic blunt trauma injury.
Is there anything about that injury that would suggest to you it had to have been something sharp or ridge-like to cause?
Objection, Your Honor. We again request kindly a sidebar on this.
All right, we'll come to
Thank you.
So they go to sidebar, and when he gets back, he says, "Oh, we're gonna hear that." No, sorry, we're not gonna hear that part. I don't think. So after sidebar, he comes back and he asks that question again. First off, I think Hank Brennan has already gotten the information he needs. He already said no, it did not have to be a ridge or an edge. Move on. But he asks another question, and after sidebar, the witness says, not necessarily. Not necessarily did it have to be a ridge or an edge. From my perspective, that leaves the door open, where the door didn't seem open after he first asked about it. And then, this was really interesting. By the way, you want to know why else you call a witness like this? It adds credibility. Just like we said Burgess was such a catastrophe for the Commonwealth, a witness like this adds credibility to the Commonwealth's entire case. Because whether or not he's the most groundbreaking or important witness, he's not. We knew a lot of what he already had to say. But when you get a guy like this to come up and sit there and say, he's with us, he's on our team, and you put your arm around him, the exact opposite of this guy Proctor, no, we don't really know him. We don't ride with him. Even Burgess, it's like, ugh. But this guy, it's like you want to put your arm around him and be like, we ride with Isaac, okay? Because it gives credibility to your whole case. And that sometimes can be effective even if he's not the most important witness. But he's so confident, he's so smart, he's not really scared to say anything. He's just going to try and explain how this works and what his experience is. But in explaining that, I think he gave some nuggets to the defense.
Or a line type edge that caused that wound?
Not necessarily.
Oh, good. We did get it. So we did get it there. He said not necessarily that time.
And have you seen, in your experience, similar types of lacerations and breaks caused by falling on hard ground?
Yes, you can see that both in the occipital region. You can see it if patients fall on the forehead. The skin tears, they're still bridging, and then they get bruises.
Some of your work was in Minnesota.
Correct.
Was it a colder part of Minnesota?
Very cold part of Minnesota.
you-
It's Minneapolis.
I'm sorry. Did you often see these type of injuries there?
Yes, I mean, we took care of a trauma center, Hennepin County. Very frequently, patients that are drunk fall down on ice sidewalks and could develop, lacerations in their head,
Come again? A+ expert? It's very common. Patients would come in, they were drunk, they slip and fell backwards and hit their head. That's not what you want as the Commonwealth. That's not the example I want him to give if I'm the Commonwealth. Pick a different example, sir. I'm sure there were people that fell different ways, sir. And guess what? That's now in evidence as his expert opinion. But Alessi did not highlight it and talk about it on cross. Why is that? Well, let me tell you, because we're going to get to Alessi's cross and how abbreviated it is. He could have dug into this. He could have been like, sir, you said drunk people slip and fall and crack their head all the time, right? Well, that would give this expert who's very smart, Because right now, I don't even think he knows what he did, right? How much does he know about the facts of these cases? How much does he know about what each side's arguing? I don't know. Sometimes experts don't know all those details. But if he picks up on that, you like that fact, and you're Bob Alessi, and you ask him about it, maybe he says, well, yeah, but not to this level. John O'Keefe's body and head was moving way faster than a normal people's. I don't know if he would have said that, but if he would have, he could be able to back it up because he knows that stuff. He would be able to potentially explain away his answer. And you have to be careful about not letting him explain away something that Hank Brennan didn't rehabilitate, didn't lessen the sting of that. Now, did the jury pick up on it? Maybe, maybe not. They're not listening to it multiple times, pausing it, talking about it like I'm doing, okay? But this is something I would absolutely bring up again, maybe even with my expert. I'd say we heard from Dr. Wolf, who said this is common when drunk people slip and fall and hit their head on a hard, cold ground, like happens in Minnesota, where he worked. It's cold and hard here in Boston. Is that something that's reasonable? That could happen here. And you know the defense expert's going to say yes, of course, to that. So don't let him explain it away on cross when he's a smart expert and maybe he feels where you're going as Alessi. I thought that was a good punch to pull and not swing as Alessi.
Durals, which are blood clots above the dura, because they fracture a bone in the temporal area and they can get a bleed from a fractured artery. And it happens when people are shoveling snow and have a heart attack and fall backwards. So there are various ways that people fall, resulting in head injuries and lacerations to their forehead or to different areas of their head.
Can somebody suffer this?
So again, I don't understand why that, Kevin said, I don't understand that why they thought this testimony would help. It absolutely helped because I think the defense, we don't know what the defense experts are going to say yet, right? So what is this going to contradict? And I expect at least the defense experts are going to say it's a ridge injury, right? Maybe it hit an edge or whatever. Or at least it's more likely that. He dispels that, number one. So I do think that's important. Additionally, the raccoon eyes, the way he explains that, it's not a fist fight. Somebody's not getting punched in the eye with those types of injuries. Important. And I think he's locked, loaded, credible. The jury's going to believe what this guy says. And then the third thing, having a guy like this on your team usually reflects well. That's what I would say.
This type of injury simply by falling backwards.
Absolutely.
You had taken us through the process of falling backwards and then talked about what happens to the brain. Can I ask you a couple of detailed questions about that?
Sure.
When you explained that the brain upon impact then shifts forward and hits the front of the skull, is there a medical term for that process?
Well, the medical term is a coup counter coup injury. So the coup is when you first hit. In this case, it was the back of the head, as summarized by the laceration in the back of the head, and the contusions that the pathologist and the ME found in the back of the brain. And then the brain shifts forward, and as it's traveling at a certain velocity, because it's thrust forward on the floor of the base of the skull, it's getting bumped. And it's getting, again, you can think of it as a hammer hitting a thumb. It's getting black and blue in the areas that are sharpest.
Are there symptoms that result of the process coup counter coup?
This is clinically, it varies. I mean, you can go from anywhere from a simple concussion where you sort of are unaware of what happened, but you're still awake, you're confused, all the way to, ultimately being in a coma.
Can this type of injury, the coup counter coup, and what you see in the review of your files, could this type of injury happen from an attack by a weapon, like a bat or a hammer?
Well, he did not have a depressed skull fracture. So any focal hit like that would more likely than not have caused a depressed skull fracture.
That's not a reasonable degree of medical certainty, first off. So I would probably object to that if they try to use that as his expert opinion in the future. But that's also another point he made, right? To diminish the opportunity for it to be a bat or something like that. I thought that was good testimony. Additionally, there was something else I was going to say that he got out. It'll come to me. But he definitely made some points for the Commonwealth. I think he gave the defense some opportunities as well, but he definitely made some points for the Commonwealth.
Blunt trauma, the way he had, the assumption, would cause the coup counter coup without a
The assumption? What did he mean by that? I don't know what he meant by that.
depressed skull fracture.
When the coup counter coup process happens with the skull
By
fracture,
the way, as a dummy myself, with the language they're using, to me, what I'm picturing is the brain bouncing back and forth doesn't happen if he's hit the way that the defense wants to say, but it does if he hits his head on the ground. Could have been a slip and fall or whatever, but it wasn't a fight. That's what this guy's trying to say. I thought it could have been a little simpler personally, but that's what I'm picking up.
does anything happen to the front of the skull?
Well, you're asking me, does the rest, I mean, the forces, depending on how hard they are, can generate fracture lines all the way to the anterior fossa. So you can have fractures along the lateral temporal area. You can have fractures along the orbital roof. The orbital roof is very thin. And so those forces can go all the way to that area.
Did you see any sign of orbital fractures in Mr. O'Keefe?
Yes, he had both the ME and the pictures taken, and the neuropathologist mentioned fractures of the orbital roof
Do you have an opinion to a reasonable degree of medical certainty how those fractures occur?
from the trauma.
Could you just explain a little bit how that would happen?
Well, as he fell backwards and he struck his head, it was clearly at a very high speed generated by the gravity.
Very high speed generated by the gravity. I was kind of thinking he was going to say generated by flying through the air or something like that, but he didn't. He just said generated by the gravity. Interesting.
The bone, depending on the quality of his bone, the density, then generated forces. There's a certain amount of lateral give, and then you get a linear force going forward. It drives all the way up the clivus and forward into the anterior fossa where his orbital roofs lay.
Again, to me, could have simplified that. And what I like to do with some of these experts is be like, can you use layman's term? Can you point to spots on your face, maybe where this is, or on the picture or whatever? Use a diagram, use a fake skull, and point so they get how all this works. But again, they're trying to disprove a fight, punches, bat, whatever, to different parts of his skull.
And this is why people like this get what they call raccoon's eyes.
Do you have an opinion whether the brain itself could have caused the orbital fractures?
No, the brain is a soft substance. You could literally put your finger through the brain. We often operate on people fully awake. The brain couldn't possibly cause a fracture. The fracture was caused by the forces generated through that clivus, that middle bone in the middle of his base of the skull.
Do you have an opinion to a reasonable degree of medical certainty whether or not the brain in any way could have caused these orbital fractures?
The answer is absolutely not.
In your study,
And will that be something that the defense expert disagrees with? To be determined. To be determined. Ashley said, notice how Brennan didn't say grass at all. Yeah, he said the hard ground. He didn't say grass. That's true. LM, how about hitting a floor or falling downstairs? I would think that like boom, 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 boom on a bunch of stairs would probably be different, but those type of questions weren't asked. Could he have been hit by a beer bottle? I think that's probably along the similar lines as a bat in the questions that he said. It's not, it's more probable than not that that's not how this happened.
of the records and photographs, and in your experience treating these types of injuries, do you have an opinion to a reasonable degree of medical certainty whether or not a person would remain conscious or would be immediately unconscious after the impact of the ground?
Well, it's impossible to know whether he became immediately unconscious, but his injuries were very substantial. And it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
What does functional activities mean?
The ability to, get himself up and about would be one of the functional activities. The ability to call for help would be a very significant cortical function. And that's why I was talking about, that there's a variation on the theme from a simple concussion to a severe concussion like this.
If a person,
So again, I love this guy. I think he seems really smart. That I didn't think was great. That I didn't think was his strongest opinion. And almost logically, I'm not sure what he's trying to prove with that. And then he starts talking about like the caveman theory. Could, what we do to like make an animal go away from us or whatever. He could have been doing stuff like that. What's the Commonwealth trying to use with that? Is that the Apple phone health data? Like, that's what you're going with. I didn't think that was the best or most logical explanation personally. Could very well be true. I don't want to, match brains with this guy, no pun intended, but I didn't think that was great personally.
Does not have functional abilities because they are rendered unconscious. Does their body, could it still move?
Yes, this is the interesting thing about our brain. So the cortex, which is the top portion of your brain, can get separated from your brainstem functionally. And what happens then is that your body is not acting autonomically, meaning vegetative. So why does that happen? We think it's because as we were a caveman, and if a caveman became unconscious, as an animal came up to eat it, the animal would touch it. Well, you have these automatic movements. One of them is called decorticating, which is where you draw your arms like this and you throw your feet out. And then a worse neurological situation is when you decerebrate. Now you push your arms out along with your legs. And that would scare off an animal. So we think that over time, genetically, this is what happened to our brains in order to create these. But those kind of movements are not thought processes. In other words, your brain is not telling you, oh, you have pain, go ahead and decorticate or decerebrate. It's an automatic movement in response to pain.
I want you to take us back now to after the fall. Would Mr. O'Keefe, in your study and opinion, have died immediately?
No.
Can you share?
I don't.
I'm sorry.
Yes, I'll tell you. There is very few things that you head injury with you.
So this I thought was interesting too. Like, would he have died immediately? He says, no, probably not. He explains kind of in graphic detail a couple different ways that you can, but he doesn't think you would die immediately. And again, does that mean he'd be like using his phone and taking 36 steps and all that stuff? Another thing, unless he didn't ask him. And if I'm going to guess as to why, strategically thinking, his opinion is when he talked about movements that could happen while we're unconscious, caveman theory, it's arms go up, legs go out, arms do this. It is very clearly not get up, take 32 steps, look at your phone, lock your phone, call for help. He actually said you wouldn't be able to call for help. So I still think this is pretty in line with what the defense wants to argue. That's my opinion as to why Alessi might not have gone there. Let's answer a couple questions. Did you notice this surgeon said that the head injury consistent with the head injury striking ice or sidewalk, not frozen ground? I think those are kind of similar. Cena, is it a mistake not to call Stonebridge? I don't know, right? It's hard for me to say, is it a mistake? We also don't know if they are going to call, who is, or if either side is going to call Dr. Stonebridge. Big Apple Hoosier polls, second best lawyer, AJ, Alessi, or Yannetti. You guys vote in the chat. Mike Berry, I missed the relevance of the 1236 timestamp that the Commonwealth has still explained. Why does it affect Karen Reed innocent/guilty? So how I would use it if I was a defense attorney is, how is she backing up at 1232 and then back at One Meadows by 1236? In the snowstorm, I think that's probably close to impossible. I believe Karen Reed is not guilty and possibly innocent, Gingy Prob said, and general consensus seems to agree. But I want other point of views. Canton Confidential yesterday was so pro-Commonwealth, it made me wonder if I'm just in an echo chamber. Thoughts? That's why I like to watch the evidence all day. I like to try to think in my brain, what was good for the Commonwealth on this witness? And I did a lot of that with this witness, and I could come up with a few things that were really good for the Commonwealth. There's still one major question that's unanswered. How could a car have hit John O'Keefe? To me, echo chamber or not, everybody has to find an answer to that. Just because the car was there, John O'Keefe was there, Karen Reed was there, and they were drunk is not going to be enough for me. Will it be enough for the jury? Potentially. It was enough for some last time. Class Act Beauty. I thought this witness was good for the defense. Why don't you think the Commonwealth didn't ask about the injury and getting hit by a car? You're amazing, Peter. Well, a couple reasons. Number one, maybe they didn't ask because they weren't going to like the answer this guy gave. More likely, they didn't ask because he's a brain surgeon. He is not going to testify to orthopedic injuries, arm injuries, scratches, broken bones, bruises to the arm, leg, whatever may or may not exist or whatever allegations may be there. That is not for him. That is not within his expertise. That's why My guess is they didn't ask him. Lady Page, Peter, my husband gets jealous every time I watch your videos. He calls you the Greek god. Thanks for all your insight. Your husband sounds like a legend. Sounds like a legend. I just want to know who. Oh, wait, hold on. I want to save that. Save that. My mother thinks you look like Nick Newman from The Young and the Restless. I don't see it, but she loves you. I got to look that up. I don't know. I don't know who Nick Newman is, but I'm definitely going to look it up. Peter, the tush push lives on. I saw that. I saw that. Peter, as great as Alessi is, I believe it was a missed opportunity to say to Shannon, you changed your dates, but you never corrected your non-existent Bachelor's of Science. Sorry for the late response. I don't know. 11K from 500K. Let's go, Laura. Yes, everybody, if you haven't hit the like button, hit it now. Okay, now we're going to get to his discussion on hypothermia and then his kind of final overall opinion.
About 98, 98.6. 95 is very mild hypothermia. When you get to 82 degrees, you're in severe hypothermia. What happens?
I probably would have objected to this as the defense too as well. Like, is this within his expertise to talk about hypothermia? Maybe it is. I don't know. Yale, summa cum laude. Who am I?
When you're hypothermic, and I'm a neurosurgeon, but I can tell you that
right when he said that, I might have objected. You're right, sir. You're a neurosurgeon. Maybe let somebody else discuss this.
You get into multiple organ failure. Your heart starts to have problems. It can have arrhythmias. You're not breathing. And ultimately, at hypothermia, you also become unconscious and go into a coma-like state. Below 80 degrees, you're probably going to die. So all I can tell you, it wasn't helpful that he had a significant head injury and that he was then found hypothermic.
So that was an interesting explanation. He had a significant head injury and then was found hypothermic. He didn't talk about how hypothermic he should be for being out there for 5 hours. Is somebody going to explain that to us fully? Because I'd like to know that. Did his body temperature indicate he had been out there for 5 hours, 2 hours, 1 hour? Can we not tell? Why can we not tell?
Is it uncommon in your experience for people that suffer this injury to pass within 5 hours?
Well, none of the patients we treated died within 5 hours, but it also didn't mean that we didn't realize that they were going to be in a potentially vegetative state. When someone's hypothermic, you have to warm them up in order to establish a clinical status, meaning you can't declare someone dead with a temperature of 80. You have to warm them up slowly, appropriately, and then reevaluate where they are clinically.
I've asked you questions about whether you had an opinion about Mr. O'Keefe and when he died. I want to ask it in the form of a formal opinion. Do you have an opinion to a reasonable degree of medical certainty whether Mr. O'Keefe died immediately or within 15 minutes?
No, I don't think he died immediately. Neither the hypothermia nor this kind of head injury would kill you immediately in any clinical experience I have.
Dr. Wolf, thank you.
So what does that mean, right? And you guys tell me, maybe I'm missing something, but to me, I don't think it means he was walking around with his phone or looking at it or unlocking it. So I don't think it helps them there. But does it hurt the defense if wherever he got this skull fracture, he lived for 15 minutes? Maybe on count 3, leaving the scene knowing that she had hit him. I don't know. I don't really know how effective that really was for the last portion, because I don't think anybody's actually going to believe that that he's getting up and walking around, right? Which is kind of why the defense is saying he didn't die immediately. All right, now we are going to jump in and talk about cappuccinos for a second as we get to this guy's daily routine. And again, you may ask yourself, why is Alessi asking this question? It gives this guy an opportunity to make the jury like him even more.
Morning, doctor. I don't think we've had the pleasure of meeting. Welcome.
Thank you.
Sir, can you just describe, you started to do it a little bit on direct, a typical day for you?
I wake up at 4:15 in the morning. I go to my center. I set up patients with frames for their either radiosurgical procedures or stereotactic craniotomies. I go home. I make a cappuccino for my wife at 6 o'clock in the morning.
And look at Alessi's little smile and smirk. It's like everybody likes that guy, right? Mr. Yale, summa cum laude, goes to the office at 4 a.m. It's like, whoa, right? Like he's showing off at this point. A lot of people are asking, could it have been this? Could it have been that? If the jury has the same questions and the Commonwealth doesn't prove it wasn't that, that could be a reasonable doubt. Then he goes back home to his house to make his wife a cappuccino at 6 a.m. Somebody asked who made his wife a cappuccino. Well, probably him, right? He wasn't in court at 6 a.m. He's probably making his wife a cappuccino. I think that makes him incredibly likable again. But I do think there's a method to Alessi's madness. He didn't ask a lot of follow-up questions, but here's what I got when this guy was describing his daily routine.
And then I get back to work at 6:30 and move on. I have patients that I'm operating on, and I have patients that I'm seeing through the day.
What type of patients and what type of work? Just in a typical day. What are you doing? What type of patients and what do you do?
It varies. I mean, I see patients with brain tumors. I see patients with hydrocephalus, which is water in their brain. I see pediatric brain tumors. I see subacute and chronic subdural hematomas, post-traumatic. I see patients with strokes that are being misdiagnosed. I see patients with cancer, metastatic disease.
He's saying a lot of patients with a lot of issues. He does a lot of work, good work, important work. He's very smart. But what are you not hearing?
I used to see patients with cervical problems. I stopped doing that 2 years ago. I mean, I don't know what else you want me to tell you.
No, that's great. And is that typical day, typical of the type of days you've had for the past month, past few years? Is it generally, without specifics, is it generally?
Correct.
Okay. So what I thought and what I wrote in my notes is he didn't mention car accidents. He didn't mention trip and fall, head injuries. He didn't mention emergency medicine. He didn't mention any pathology. He didn't mention any medical examiner type work. He didn't mention anything with hypothermia. I know Brian B said, sometimes they cool the brain. Fine. He didn't mention it. So his daily work, what he's an expert at, what he dedicates his entire life to, has nothing to do with what we're talking about in this case. Now, I know it does, and I know he's talking brain injury, and I know he's a brain expert. I think I've, glazed this guy enough, okay? But what he just said he did all day, every day, where he is the king of the castle, in my opinion, if I'm Alessi, I'm like, it's not what we have here. And we're going to have experts that are heavily in this. We're going to have Dr. Russell, who's going to tell you how many dog bites she's treated, how many car accidents she's treated. She was a cop, an ER doctor, an ME. We're going to have a pathologist come and testify to you. And that, to me, is a really great dichotomy. And the cappuccino thing, don't underestimate a smart lawyer using a memorable moment. I love when I have a quotable moment, either from my expert or their expert. Everybody is going to remember the 6 a.m. cappuccino. So if you're Jackson or whoever's doing the closing argument, while Dr. Wolf is making his wife a cappuccino and doing brain surgery on children and adults, Dr. Russell's in the ER, treating car accidents, treating dog bites. Dr. Russell is looking at bodies after they've passed. He said all of his work is basically from when somebody's injured to when they either get better or they pass. The work done in this case is after he passed. And I don't know all the defense experts, but I would compare and contrast them with what he said. Genius, smart guy, maybe smartest guy in the room, literal brain surgeon, but not as helpful to this case as these experts. That's something I would do. Okay. And I don't want to argue with him, right? I'm not going to point it out to him. I'm not going to say, you shouldn't even be here. I'm not going to do that to him. Now, unless he asks him a little bit and this guy has a snapback, and again, an explanation that maybe the jury will buy, I'd rather not let him explain it. I'd rather do it myself in closing.
So none of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist.
I am, you could have asked that question, very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Right.
He's like, hey, you don't have to wiggle around it. You don't got to stutter through it. Ask me straight up like a man. Am I a pathologist? No, I'm not. I'm a brain surgeon. Right? I mean, even that answer was a little like, so it's like, you did it. You asked the question, but you have gotten what you need. You've gotten what you need by asking him the question, throwing the bait out there, and he took it. He took it. He explained his day. He explained what a king he is. He explained what a great husband he is, what a great brain surgeon he is, how smart he is, how much great work he does. But none of it has to do with car accidents, dog bites, or trip and falls. You can't tell us the causation and what happened. You're not helping with that. Was there any more we want to play from this? Yeah, a little bit more.
And you don't perform autopsies, correct, sir? You're a brain surgeon.
Correct. In other words, I see more brains than the forensic pathologist.
Right. And is it correct to say that the brains that you...
Yeah, as the more you talk about it, the more explaining he gets to do. He's like, actually, I see more brains than a forensic pathologist. He's probably right. He is right. That's why I don't want to really argue with this guy. I got what I needed. And he said he's not a pathologist. You didn't even need, unless he probably asked 5 questions, he probably only needed 3.
you see are of living people?
Correct.
Okay. So what I'd like to do
That was a good question. Most of what you see are living people.
is to go to a different part of the head than was discussed, but sticking with the decedent.
Excuse me, I didn't hear the last
I'm
word.
sorry, with the topic is going to be Mr. O'Keefe, the decedent in this
Okay.
matter, sir. You testified about raccoon eyes. The medical term for that, sir, is ecchymosis, right?
Correct.
And ecchymosis, raccoon eyes, does not cause a laceration to form on an eyelid, does it?
No,
Are you aware that Mr. O'Keefe had a laceration to the outside area of his right upper eyelid?
I am aware that the ME described that. Yes, sir.
And this was smart. And he could have even extended it to some of the arm injuries, but he didn't. But let's talk about that. Let's talk about that eye injury. Does that have anything to do with his head hitting the back of the ground? Could it bouncing on the ground have caused the injury to the front of his eye, front of his face?
Now, could, Your Honor, I'm going to, with Your Honor's permission, ask to publish what is already in evidence in a moment.
Okay.
Mr. Wolf,
What exhibit number, Mr. Alessi?
we're going to, 165, Your Honor.
Okay, go right ahead.
Thank you. Dr. Wolf, have you seen this photo depiction before today?
I believe I have.
Is it correct that that injury on the upper right eyelid is caused by the application of force directly to that area of the front of the head, again, namely the upper eyelid?
That's possible, yes.
Is it more than possible? Is it probable that that injury was caused by the application of force directly to that area of the front of his head?
Well, an easy answer to that would be is that that's not part of the periorbital ecchymosis.
Thank you, sir. That was a
By the way, I didn't even realize this when I watched it the first time, but what I was saying as far as if you give an expert like him a chance or you ask him a question for something that came out that was good for you on direct that he might not have even known was good for you, when you ask that question, this guy knows where you're going. Multiple times he's been like, you could have just asked me if I'm a forensic pathologist. I'm not, I'm a brain surgeon. And right there, he's like, I think what you're getting at is no, this had nothing to do with the brain injury. He knows where you're going. He knows the points you're trying to get. And if he has an opening, he's going to take it. So it's smarter to just pick the spots you know you can get. Bob, hi, Peter. Got to fix that collar, though. Love the coverage. So collar is one of the things for me. It looks like a very nice suit, a very nice shirt, a very nice tie. You guys know I don't like making fun of how people look. That collar just bothered me. It's like you're this very well, and I always have that fear myself is like, I'm going to be talking and it's like this, and it's like, that's just brutal. In court with a nice suit on and your tie is all crooked. I hate that. It just bothers me. That's part of my OCD.
exactly going to be my next question. This injury is unrelated to any of what you've been describing, the fall backwards, the force transfer inside the skull, the, as you described it, the dura, the cerebral spinal fluid, all of that dynamic that you so ably described on your direct examination, this injury has nothing to do with that, correct?
Correct.
That's it. That's all he's got. So that was the end of his cross. And then Ms. Hanley is back. Let's see. I'm going to answer some questions here. Disco. Wolf was very credible, but also felt somewhat irrelevant. JOK could have fallen anywhere. Prove there was a collision. P.S. Give my wife a shout out, Daddy Pete. Interesting for a husband of a wife to say that. Okay. What's up, Disco's wife? What's up? Cecilia, why do they assume John O'Keefe was alive when found? Isn't it possible that low body temp was due to being dead for some time, especially with a skull fracture for 1 to 3 hours? That was something I didn't mention. He said that those raccoon eyes can take 24 to 48 hours or 1 to 3 hours. I wasn't real sure on that. Unless he didn't hit on it, I'm not sure if it's going to become a bigger point or not. Meg, Commonwealth contends a side swipe that shattered a tailhead into 47 pieces generated enough force through gravity only to perfectly drop John O'Keefe on the back of his head. The evidence is not adding up for me. And this is why the accident reconstructionist is potentially the most important witness. This guy seemed very legit, real expert thoughts. I absolutely agree. Absolutely agree. He didn't prove the ultimate issue that we need proven, but I agree. Paw Printed Heart, off topic. Why does the Commonwealth call the taillight plastic when it is actually polycarbonate? Polycarbonate is 10 times harder than plastic. Isn't that deceiving to the jury? I think in layman's terms, that's probably an appropriate verbiage, parlance, as they say. Sam, a little late. I'm a neuropsychologist. Coop, counter coop can happen with any forceful head strike, regardless of manner, ledge, flat ground, baseball bat, etc. How many miles is there between Fairview and John's house? I don't remember exactly, but I know that it takes longer than 4 minutes, even without a snowstorm, I think is what people have been saying. We'll wait till it comes out in evidence. It hasn't come out in evidence, in my opinion. Maybe I've missed it. I don't know. So much is going on, right? Got to be careful with what you say, because I'm pretty sure it came out in the first trial, and we'll see. You guys can correct me in the chat. Peter, can you estimate how much this doctor was paid by the Commonwealth for his brief testimony? Certainly more than a neurosurgeon expert in Florida, right? I would say if a surgeon has to block half a day or a full day of surgeries, it is not uncommon for them to make $10,000 for this test, for just being in court today, not including his prep, if he did a report, any prep time, things like that. It's probably in excess of $10,000. I think the Commonwealth may claim Karen Reed backed into him hard enough to bump him into the curb, then he fell and hit his head. They mentioned a couple times already about seeing the curb and the shape of it, but how would he end up where he ended up then? Somebody said this guy in an EDB's chat said this guy sounds like Vin Diesel, and I can't unhear it. Family. Never turn your back on family. Poops, boops, and scoops. Peter, chill. Remember, you're my wife's hall pass. How do you run a firm, huge YouTube channel, and scratch golfer? I just got laid off. Tell my wife how awesome I am, please. Sounds awesome. Sounds awesome. Poops, boops, and scoops. Yeah, Aaron, Tanya, I've heard this before. The difference between God and a surgeon is God doesn't think he's a surgeon. I have heard that before. Michelle, Peter, can you give a shout out to my friend Emily? I introduced her to your channel and she loves you. We are ordering our Lawyer You Know merch tonight. Send some pics of Michelle and Emily and the Lawyer You Know merch. We'll get it up on our Instagram page. Shout to Emily. Thank you, Michelle. What breaks me is John O'Keefe's family will think Karen Reed got away with it, or that law enforcement, the McAlberts and the prosecution have lied the whole time and they lost their son, and it's been a spectacle. It is a brutal feeling thinking it's possible this case ends with nobody really knowing what happened. Maybe not. Maybe not. We'll see. I missed the start. Do we know what the juror questioning was about? You know what? I don't know if I read this. I was supposed to read it off the top, and I don't think I did. Ted Daniels tweeted that Karen Reed, at the end of the day, said that she could not reveal why jurors were questioned this morning. We have had these before, so we just wait for the judge to evaluate and let it play out. That is what Karen Reed told reporters. So thank you for asking that question, Chris. So we don't know, but it is a juror issue. We heard none were struck. Will some get struck later? Will that add to what people are saying? This is unfair. Something's going on in the background. That something is nefarious here. We'll see. All right, let's jump to Ms. Hanley. These are the witnesses. I have been begging the entire trial for Lally to stop using so many numbers and instead give the number a name. Alan Jackson did it on cross and it worked masterfully. I had trouble following Lally's direct. I really couldn't. I knew that the glass from the cocktail glass didn't match the glass on the bumper. I couldn't really pick that up while Lally was on direct. Maybe that was done by design. I don't know. But I thought his direct was very confusing, not helpful, didn't do a lot for the Commonwealth, except for the end, which I thought was helpful. And that's what we are going to listen to, because I want to try to show you what, the best parts I got for the Commonwealth in their presentation of each witness. And this was, I thought, the best 2 minutes of this witness. That was a lot of numbers and a lot of confusion. And she didn't want to call them names. She wanted to keep calling them by the numbers. And I was like, too bad. We all don't know what you're talking about when you're talking about the numbers.
Was compared from both items.
Now, from your comparison of starting with the clear plastic from the debris from Mr. O'Keefe's clothing, from your comparative analysis of that clear plastic to the clear plastic from item 3-1, the taillight, what did you conclude?
So the clear plastic from the debris was found to be consistent in color and instrumental properties to the clear plastic from the taillight. So accordingly, the clear plastic from the debris could have originated from the clear plastic from the taillight or from another source with the same characteristics.
And with reference to the red plastic from item 7-18.18 from Mr. O'Keefe's clothing, in your comparison of that red plastic with the red plastic from the passenger side taillight of the defendant's vehicle, item 3-1, what did you conclude from that analysis?
So the red plastic that I sampled from from the debris from the clothing from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight. So accordingly, the red plastic from item 7-18.18 could have originated from the red plastic that I sampled from the taillight or from another source with the same characteristics.
I'm sorry, Your Honor, if I could just hold on 1 minute while the sirens pass. May I approach again, Your Honor?
Yes. Actually, is this a good time to take a break, Mr. Lally?
So that was the best part. The red and clear plastic matches the taillight was debris from John O'Keefe's shirt. Will there be jurors that say, oh, the way it was collected in the chain of custody, that's bad, we can't trust it? Maybe, sure. Will there be jurors that say, how the heck is that possible unless she hit him with her car and the taillight exploded into a million pieces and that's how the debris from the taillight got into his shirt/sweatshirt? So I think that's important evidence. I think if there are jurors, and you're starting to see, because of how many contradictions there are in this evidence, where it's like one says black, one says white, it's like you can see how this case ended in a hung jury. You can see it. Because if there's a juror that really believes this happened and they keep saying, oh yeah, that lines up, or somebody says absolutely not, then it doesn't line up. Too much reasonable doubt. You'll never convince me to vote guilty. And I think that's possible. All right, let's listen to Jackson's cross, because I personally thought it was considerably better than the direct. It was much clearer. Once he got there, he set it up and explained it. And again, I thought it was much clearer personally.
You were just talking about some plastic pieces in 7-18.8, correct?
It was 7-18.18.
0.8.
Michelle, literally, that's how I felt. Like in fairness, I'm not a juror. I would be taking notes and say 7-12 is this piece of evidence. So I get that. And hopefully they are doing that. But like I'm listening while I'm working, doing other stuff, whatever. And I like have no clue what she's talking about half the time. I really have no clue. And I don't know if that's done by design, Lally, but
18. I left the one out. 7-18.18. We're dealing with a lot of numbers. I'm going to see if we can cut through that here in a second. First of all, you
and I
indicated
think that was so smart to say. Now, it's not a question. Could have been an objection. Lally was objecting to all of that last trial. Brennan is not, because Brennan's also doing it. So all the lawyers are kind of throwing in these comments here. I thought that would be endearing to the jury, and the jury being like, yeah, same.
that you were doing comparative analysis in different, sort of different categorical ways, using microscopy, using the microspec, using the FTIR. I think you also use the FTIR in that as well.
Yes.
And you indicated that your analysis concluded with those pieces could have come from the same source, from the source in 3-1, the taillight. But you're not conclusively saying they did, correct?
It could have come from, they could have a common origin, or it could have come from another source with the same characteristics.
Right. So in other words, another way to say that.
He's trying to make this a reasonable doubt. It's like common origin, or could have come from that taillight or something else that's very similar to that taillight. Basically, that one doesn't hit as well with me. And this is, I think, what he decided to start his cross on. The whole chain of custody and Proctor, mixed this stuff and there was debris in the bag and blah, blah, blah. Those types of questions to me are better than this. But I guess, if you're fully on board with this and you think it's a absolute innocence, then maybe if you're that type of a juror, then maybe you're buying this as well.
Ms. Hanley, it may have come from the taillight, may not have.
It's a possibility.
Okay. I also
But that was a pretty good answer, right? He got a pretty good answer from her.
want to ask you real quick about the taillight manufacturer. You were shown an exhibit. I think it's exhibit 200, and I think we have that available. With the court's permission, we don't have to cut the lights. I think the lighting is just fine. This is exhibit, or a photograph of exhibit 200 that you saw just a second ago. Quick question about that. In your inspection of that taillight, it's true, is it not, that is manufactured entirely of plastic or plasticine pieces? There is no glass in that taillight, correct?
And that's important. There's no glass in the taillight. And this is where you start to learn how lawyers are constantly building foundation, adding witness after witness. They've asked this to 1 million witnesses. The jurors all thinking, yeah, the answer is no to this. She ends up saying no. Some of them haven't been as strong, but when you ask almost every witness and you confirm no glass in the taillight, this right here, this witness and the demonstrative aid he's about to put up, which is the best demonstrative aid of this entire trial, in my opinion, so far, because it does exactly what a demonstrative aid is supposed to do. This is why it's so important.
I have to check my notes. I don't think I noted any glass.
Okay. So in other words, you didn't note any glass inherent in the manufacture of that taillight. It's basically plastic.
Yeah, I think most of the parts were plastic. I'm not 100% sure if the entire thing was plastic. There may have been other material, but portions were plastic.
But you certainly didn't see any glass inherent in the manufacture process.
I'd have to double check my notes, but I don't think I did.
Okay.
Do you want her to check her notes?
Why don't you?
No problem.
Are your notes in front of you?
Yes.
With the court's permission.
Yes, sure.
Final point.
Okay, so I did not make any notation that I noted portions that were glass.
Great. Final point before we get into the actual analysis. On any of the glass, I want to shift gears to just the glass material that you analyzed and that you looked at and you inspected. You saw no blood, no skin, no biological material, no tissue, human tissue or otherwise, on any of those pieces that you inspected, did you?
Upon examination of those items, making observations of those types of material, that's not my area of expertise. I don't think I noted anything that was maybe consistent with that.
So in other words, even though you're not in the bio material expert section of the lab, you certainly would have noted if there was skin or biological material or obvious blood on glass pieces. You're looking at them in many cases through a stereo microscope, correct?
Yes, I would have made note of observations of anything that I would have noted on the surface.
Great, and you did not. Because you didn't see anything that was suggestive of that, right?
I think I just made note. I'm gonna have to check each item, but I think I did note that there was some dirt debris on some of the items.
But not biological material.
I did not note anything that would be maybe consistent with that.
Great.
Right. And that's all he wanted, right? So there's no like blood or anything on the taillight, which again goes to the planting conspiracy, those kinds of things. And that's what he wanted to get out of her. So there were some clunky, slower parts of Cross, but he gets the Buchanan and Proctor's names on the bags. And then when he gets to naming things, 3-2 is the cup, 3-3 is the bumper glass, 7-12 is the Buchanan glass, 7-14 is the Proctor glass. And I was like, oh, that's interesting. And then I want to say, did this demonstrative not get in the first trial? Was this something that Jackson was trying to get in, but he couldn't get it in? Is that what happened the first trial? I can't remember. But I thought this was such a king moment for Jackson, because what are you supposed to do with the demonstrative aid as a lawyer, right? You don't want to use too many. They've got to be necessary. They've got to be simplifying and explaining something that the jury needs help with and needs to be simplified. And you've got to do it in a way that is not too much information, pictures and words together. I like to use, I say this all the time, like in openings and closing, I like to use arrows and circles and timelines with, even like clip art. It can be as simple as clip art, because words do something, but also those clip art, whatever it is, like he has the circle with the line through it. That is an image that tells the jury what he means and what he's trying to do. And that demonstrates what you're trying to do with less words, more imagery, and it can be more captivating depending on what type of learner the juror is. And you have to present something as a lawyer that is good for every different type of learner. Listening, seeing, reading, hearing, whatever, right? Whatever the type of juror is, you've got to hit all of them. And to me, after he very clearly set out, this number means this number means this, which I've been begging Lally to do all trial, I thought this was incredibly clear. And Ashley, I'm going to answer your question in a second after we get through this chart.
Is Exhibit 205 in evidence on the screen?
Yes.
Is that consistent with what you and I were just talking about at the witness stand?
Yes.
If you'll direct your attention to the screen on the right, just because it's a little easier and I think the laser pointer shows up a little better. You see the 4 categories represented in this exhibit?
Yes.
Okay, so 3-2, I'm going to go over it very quickly one more time, just visually. 3-2 on the left is the cup, correct?
Yes.
3-3 represents the 5 pieces of glass of what we call the bumper glass, A, B, C, D, and E, correct?
Yes.
7-12 is the 9 pieces of glass recovered by Trooper Buchanan at 34 Fairview, correct?
Yes.
And finally, 7-14 is the single piece of glass recovered by Trooper Proctor, correct?
Yes.
Taking these one by one, just so everybody see. Taking these one by one.
He's like, can everybody see? I want to make sure everybody sees my pretty demonstrative aid, because this is going to be really important as we go through it. So can everybody make sure they see? And while everybody making sure they see, we've been going for an hour. We're going some overtime today. Probably not an hour and a half. So we're going to get this done in probably the hour 15-minute mark. So make sure you hit that like button if you guys haven't already. Make sure you are subscribed. Make sure you have your membership gifting ability to accept them to be turned on, because Mo and all these other people gifting memberships is so awesome. I appreciate you guys so much. We did get one of the videos to 40,000 likes, which is a record by far. Let's see how close we can get this one. If everybody hits the like button, we can probably get there. So thank you guys for hitting the like button.
Looking at starting with bumper glass, category 2. Piece A did not match the cup, anything in 712 or anything in 714, correct?
That's correct.
Piece B did not match the cup, did not match anything in 712, did not match anything in 714, correct?
That's correct.
And moving over to category 3, there were some matches in these 9 items, 6 of them, A, B, C, D, F, and K, correct?
Yes.
But what those matched, Ms. Hanley, with a cup, nothing on the bumper, correct?
Correct.
And what didn't match the cup were E, I, and L. Is that right?
That's correct.
Moving back to category 2, however, there was one thing, item E, that did match something in this series of categories. Isn't that right?
Not a physical match, but instrumentally there was consistency.
All right. And this is an item, the only piece of bumper glass, the only piece of bumper glass to match anything else in your analysis, matched what? What was consistent with what?
Item 3-3, piece E, was consistent in physical and instrumental properties with the sample that I took from item 7-14.
Which is
And so she like almost refuses to use names. So she keeps using numbers, which is, again, thinking a step ahead for Jackson, not just putting the names. Once you've connected the names, he put the number 2. So when the jury's looking up there, everybody knows what 7-14 is for the first time this whole trial. At least I'll speak for myself. This demonstrative aid very clearly shows that not a single piece of glass they tested from the bumper connects to the cocktail glass, which is the only thing that really makes sense. If he's hit and he's holding the cocktail glass, it shatters and ends up on the bumper. How the heck does it end up there during everywhere it was driven that day? Tow trucks back to John O'Keefe's house, blizzard, wind, whatever. Who knows about that? But now we don't even know how it got there. If it wasn't from the cocktail glass, it was only from a piece of glass that the Commonwealth says Proctor got from the road at 34 Fairview. What? Think about that. We don't know where this glass came from. We have no clue. It's not from the taillight because there's no glass. That's why they're asking every witness. It's not from the cocktail glass. So what glass is this from and how does this make any sense?
a single piece of glass recovered by Michael.
By the way, I can almost guarantee you this demonstrative aid is going to be used in closing argument.
14.
Which is a single piece of glass recovered by Michael Proctor, correct?
Yes.
But not a single piece of glass, nothing that you analyzed coming from that bumper matched the cup. Did it? Nothing.
Physical match comparison. There was no physical match comparison to the cup.
Are we done with this, Mr. Jackson?
We can take this down, Your Honor.
I mean, how good was that? Right? Like that demonstrative aid to show. And so now while this demonstrative aid is up there, because I feel like it needs to be when I answer this question. What percentage are you on buying into the frame job now? So they will never be able to prove this beyond a reasonable doubt in my mind. Okay. Sometimes because of the investigation, et cetera, et cetera. I don't know what the heck happened inside 34 Fairview, if anything. I don't know if he was hit over the head with a bat. I don't know any of that. What I will tell you is I feel a very high percentage chance that almost maybe beyond a reasonable doubt that Proctor somehow put this piece of glass on this bumper. Accidental, maybe. I don't know. Maybe it got from his clothes to on the bumper, maybe intentionally. What did it actually prove? I don't know. Did he think people were just going to assume it was part of the cocktail glass? I don't know. But in my mind, Jackson did a pretty great job of saying Proctor must have gotten that glass to that bumper because we don't know how it stayed on there for that long. We don't know what that glass that he recovered. It doesn't match anything else. How the heck did this happen? He didn't prove it beyond a reasonable doubt. That's definitely didn't prove it beyond a reasonable doubt as I'm thinking through it. But more likely than not, right? If I was in a civil case and I had to figure out how did the glass get on this bumper, it certainly feels like Proctor had to put it there. Why did he put it there? Does it prove the rest of the conspiracy? Not necessarily on its own, but it would be probably enough for a reasonable doubt in this case on its own. How is this possible? What is that glass? How did it get there? And how did Proctor find a piece of it at 34 Fairview? I just don't get that. I don't get that. Man, I don't get it. Like John O'Rourke, who I think, and I feel comfortable doing this, I think you think the Commonwealth is working on their way to proving this case beyond a reasonable doubt that Karen Reed did this. What is, like, what do you, how do you deal with this? Mistake, coincidence? Like, tell me how you guys deal with this. Honestly, I want to know. I really want to know. Idaho 4 filing asking for a trial delay by Brian. No surprise there. We need a new video. So much is happening. Would love for a breakdown. I live in Boise. I am going to try to do that. I can already tell people I ain't going to hit everything. It's going to be impossible to hit everything, but I'll hit absolutely as much as I can. And I'll try to do it live so I can answer your questions as well, probably tomorrow. It came from 34 Fairview. Okay, from what and where in 34 Fairview? Right? I don't know that. Did a light smash or something like that, like a street light? I don't know. I'm looking for people that have an explanation. Yeah, I really don't care about like trolls saying I get paid by somebody. That's fine. I really don't care. Taillight has a glass bulb that nobody has testified would match this. And they talked about how it was like fine glass. Nobody has said it matches this. Trying to look. Honestly, I've been trying to look to see. Taillight's LED, no bulb. Okay. I don't know. But nobody has said it's a taillight bulb, which I think the Commonwealth would put on if they could. All right. We're going to keep going here. How do you explain the grass stains on his pants and the ripped jeans pocket? Also, his phone was found under him and he was missing a shoe. Too many things to disprove being hit by a car. I mean, I think he could hit and slide on the grass. I think that's possible. If the car, like if he had bruising and internal injuries and a fractured sternum for the car backing up into his chest or broken arm or whatever, and he flew and he dropped the phone underneath him and his shoe flew, I think I could see how that happens. Not with the injuries he has, though. That's the issue. John said Karen's 3-point turn at 12:24, sat with John until 12:31. 12:32 is when they say the backup event happened. Back at his house at 12:41. John, you're ignoring the 12:36 connecting to his Wi-Fi, which she could have done from 300 feet away in his driveway. So she was at 34 Meadows at 12:36, maybe 12:37 at the latest, not 12:41. I don't know. You tell me. You tell me. Do you think the fact that the doctor said he didn't die on impact means the Commonwealth can push back the accident? Not with all the Lexus data and phone data they have. Can lawyers hire people to make demonstrative aids, or does someone on the legal team usually make those? Absolutely, they can and do hire people to help with demonstrative aids. Sometimes people on the team make them as well. Can the jurors review the exhibits and pictures during deliberations? Exhibits, yes, not demonstrative aids. I think he said this is an exhibit. I think he said this is an evidence. I'm not positive, but I think he just said that. MAGA Barbie, doesn't the defense sort of have to call Proctor given everything they mentioned about his text in their opening? I think they should, but even if they don't, I think they can make a lot of arguments about it. Her report wasn't supposed to show that comparison, to be frank. Okay. Can't they reconstruct all of the pieces even digitally, or is that just on TV? I don't know what you mean. Of the taillight, they put them all together physically, right? Nancy, Peter, as your channel has grown so much, do you ever often find that you know who you are, that jurors know who you are and can't serve on your trial? It's only happened one time ever so far. We'll see, though. We'll see. Fair point. Thank you, John. That's why let's do this, man. And it's not just John. Other people that believe that as well, believe she might be guilty, is guilty, or they're on their way to proving it. You are welcome. Let's talk about it. The way that John does, right? Point, counterpoint. Like, I get it. John's like, debris is in his sleeve. How does that happen? Backup event right at the perfect time. How does that happen? Phone goes dead right after the backup event. How does that happen? Let's talk. Let's keep the dialogue going. Did the glass come from hitting John's car? I mean, golly, how would it have stayed on the bumper that long? Especially if she's backing up at 22 miles an hour, or if you think she's hitting a person. How does it stay on there? But that would be interesting. Did they go check? Was glass missing from John's car? I don't know. All right, let's listen to a little more of this. Or actually, that's the end of cross. Let's listen to Alex.
Now, Ms. Hanley, as far as...
Is this where I want to start? No, we're going to jump a little ahead in his redirect, just about 1 minute.
The chalk that you were just presented, as far as the 4 photographs that were depicted in there, have you ever seen any of those 4 photographs before?
No.
Do you know specifically who or where any of the items 3-2, 3-3, 7-12, or 7-4 were physically recovered from?
I just have the description that's put in the LIMS system when it's submitted to the lab.
So that's a no. She is not aware. And because she's not aware, you can't ask her or tell her where it was found, when it was found, who found it, whatever. You can't do all of that without showing the evidence bags and going through everything. And that's exactly what Lally is trying to do. And he does something he knows inappropriate. He's going to lead. Jackson's going to object. They're going to have a sidebar. It's going to get cut off. But he really was trying to push against Proctor planted that glass because that was the most important thing to come from Cross.
And do you know that 3-2, the drinking glass, was recovered by the Canton Police Department on January 29, 2022?
Objection.
Sustained.
Do you know that item 3-3, the bumper glass, was recovered by Ms. Maureen Hartnett from your lab?
So those are leading questions, right? Leading questions have the answer in the question. Do you know that the drinking glass was found by this person on this date? Not when was the drinking glass found? Where was the drinking glass found? Those are open-ended questions on direct examination, not leading questions. He knows it. He wasn't getting the answer he wanted, so he starts throwing the answer into his question, and Jackson is timely objecting.
On February 1st, 2022.
Sustained.
Do you know that each of the 4 items were recovered by different people on different dates at different locations?
They approach.
Yes.
Jackson not happy. They approach. He wins. Lally comes back. We'll listen to the rest of his redirect.
Ms. Stanley, from your conclusions that you testified about before, you found that the item 3-2, the drinking glass, was consistent with 6 different pieces from item 7-12 that were found in the roadway outside of 34 Fairview Road, correct?
That's correct.
And you also found that piece E from item 3-3, the bumper glass, was consistent.
Piece E from that 3-, it's like you lost it already, Lally. Like you just can't, you got to go slower, call it by name. If you want to add the number, fine, but slowly call it by name.
With the single piece from item 7-14 that was found in the roadway outside of 34 Fairview Road. Is that correct?
Yes, that's correct.
And you also found that items from 7-18.18, the debris from Mr. O'Keefe's clothing, were consistent with the item 3-1, the taillight housing, correct?
Objection, Your Honor.
Sustained is defense.
It's just purely leading. He's just purely leading. But he wants her to say here on redirect, but he wants to get in front of the jury before she leaves, which I do think is important, is like, hey, the glass found on the bumper matched glass found at Fairview. So wherever this glass came from, it broke at Fairview and landed on her bumper because her car was there and she hit somebody there. That's what he's trying to get out with these questions. And then obviously taillight debris in the arm sleeve.
Consistent with the item 3-1, the taillight housing, correct?
Objection, Your Honor.
Sustained is defense.
Now, as far as the chalk that you were presented with on cross-examination, was there anything in there about item 7-18.18 or item 3-1, either the taillight housing or the debris from Mr. O'Keefe's clothing?
No, there was not.
Nothing further.
Anything?
Very briefly. So in sum,
And so here's recross.
not a single piece of glass on that bumper can be connected to that cup, correct?
There was no physical match to the pieces that I compared for physical match from the bumper. There was no physical match to the glass cup 3-2.
Thank you. So another way of saying that is not a single piece of glass that you analyzed on that bumper matched that cup, correct?
Sustained.
She was going to say correct there. And it's like that's why they're so hyper focused on the glass, because that's the only thing that makes sense. Sean says, lawyer, how are you explaining A and B glass pieces on the bumper could be the same for E? Are you saying if I'm the Commonwealth, I'm just saying the glass is at the scene. She hit something. Maybe there was a different piece of glass there. Maybe he was holding another glass and it just got too shattered. And that's what I don't know. I don't know. Maybe it fell on there while it was at the police station. Who knows? Maybe it fell on there while it was on the tow truck or getting loaded up on the tow truck. I don't know, but we don't need that to prove our case, is what I would try to say if I was the Commonwealth. Peter, the Commonwealth is close to resting. We know Bev won't grant a motion to dismiss. Nope. LOL. Does the defense still present their whole case? Your strategy prediction, please. So I don't really know what their whole case is or what their original plan is. I still think, yes, you present your case. You present Russell, ARCA, you're a pathologist. You present all of that. Because I think they've done a really good job so far with all of the witnesses in trickling out what their defense is, what the reasonable doubt is, and you can really hammer it home with your witnesses. Now, all of that still remains to be seen. If the accident reconstructionist is awesome for the Commonwealth, I think that could make it a very long and difficult case for the defense. Tiffany, my Greek neighbor who knows your dad and family, when I told him your advice on starting pickleball, he said in Greek, you mean to not I don't know. Mike Kaikali? I don't know. I don't speak Greek, unfortunately. I'm a disappointment. I know. I'll have to look it up. I'll have to look up what it means or ask my dad. Yo, Pita, did he say he knew the case already? I don't think so. I don't think that this was talking about the neurosurgeon. I don't think that he said he liked the case. Michelle didn't think he was very likable. Okay. Agree to disagree. Norman's dad is, and it might just be me, right? Everybody might not think the same as me. Is Netwoman your wife in disguise? No. If there are issues with a juror, but not enough to strike, can they be forced as alternates? So I don't know how they do it in Massachusetts, but in my trials, we have had issues where it's like, we don't know how many days they're going to want to deliberate. That juror said they have an appointment in 2 days. Maybe we just make them an alternate, cut them, and bring somebody else in. So sometimes you can do that. Sometimes you can't say, let's just avoid the appellate issue. Usually everybody has to agree. So that is possible. PD10. Remember when someone planted the Albert Rock that could have cracked John's? I don't think that's what it was. I don't think that's what it was. Mike, have you considered selling a What's Up Everybody shirt? It's kind of your tagline. My life, or maybe wife, Christine, would buy it in a heartbeat. It's a regular phrase on our household at this point. We have it. I know we have it on sweatshirts. I know we have it on hats. I'm assuming we have it on shirts. John, let me know. It's a lawyeryouknow.com. Check it out. Or Kelsey, let me know if we have that on shirts. I think we do. Okay. I am going to listen to what the judge has to say at the end of the day. Her comments at the end of the day kind of give us a schedule, what we're going to be seeing and doing. And I just found them interesting, right? Because we know what happened. Kelsey said we do have that shirt in the store. But it kind of lets us know, again, what she's thinking with this jury.
All right, so jurors, I know you don't like it when we're at sidebar. We don't like it when we're at sidebar, but I can tell you that after speaking to the lawyers now, we're ahead of schedule. And they've worked very hard to get us to this point where we're ahead of schedule so that tomorrow, instead of being a half a day, you have tomorrow off. So you have tomorrow and Friday, a good long weekend. It's very, very important. Do not discuss this case with anyone. Don't say a word about this case. Don't let anybody say anything to you about this case.
There's definitely more emphasis, right? Don't say a word about it. Don't let anybody talk to you about it. Karen Reed said they can't give us the details after court to Ted Daniels. He gave us that quote. Can't give us the details right now. Judge is going to sort it out. But there's definitely more emphasis on this, discussing the case, talking about it with other people. Yeah, DMB. And that's maybe my problem with this case is I've seen so many car accidents, wrongful death and otherwise, and it's just not matching up to me.
Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. I believe next week, except for Thursday, are full days every day. Watch your social media use this weekend as well. Have a great long weekend. We'll see you here Tuesday morning, ready to go.
Court, all rise to the jury.
All right, so we're off until Tuesday. Like I said, Thursday, we're going to have a Koberger video, probably live. Friday, we've got a fun video you're not going to want to miss on the Karen Reed trial. And then we'll get my dad's take either Sunday or Monday as well. So don't worry about that. Weren't those clearly dog bites on his arm? I don't think it's clear, personally. I don't think it's clear, but I trust Dr. Russell more than just what the Commonwealth is saying as far as what the taillight did. So we'll see how the Commonwealth dog bite expert does, right? Because we're going to have a battle of experts on that point. Kim, Nick was focused on nothing else after you pointed out the untucked collar. It was a tough scene, tough look. Carrie, did the taillight come from the car she backed into at John O'Keefe's house get broken? Is the glass from that car? I think somebody said they assessed it and there was no damage to the Traverse. You know who? Did you see the two shoes in the crime scene photo at 34 Fairview? It looks like two swooshes on one is under a clump of snow right next to the other. I did not notice that. I did not pick up on that. Let's go. Can the defense call Proctor just to read his text message, or is Bev going to open up across his entire life story? She'll probably open it up to more leeway than just the text messages. But again, they could call him if they really wanted to, meaning the Commonwealth. I don't think they're going to call him just for the text message. I think if they call him, they'll get more. Peter, what is your take on the letter J on the back of John's head next to the wound? I have no idea what that's supposed to prove or not. Are people saying like there's a bat with a letter J in it? I don't know. Nobody has explained to me why that should prove something to me or be significant. The glass came from the same portal Chad and Lori Table used. Kathy, you got me. I started reading that as like a real comment. Katie, sorry about my double chat. Proctor definitely planted it. I was just saying glass can be anywhere. Peter asked where it could possibly come from. Just saying I see glass everywhere. You know who? Did you see there are 2 shoes at 30 foot? Is the same comment I already just read. Yeah, I did not. I'll have to go back and look at it. I know people were talking about the shoe a ton. The defense didn't point out, and that's where I take a lot of it. If the defense points it out, we'll scrutinize it. If they don't point it out, I'm probably not going to spend a ton of time saying, oh, that's reasonable doubt. A jury can. Believe me, they talk about stuff all the time that we didn't even think was important. Shannon Burgess removed his profile from LinkedIn. Wow. Alan Jackson could get me to confess to a murder I didn't commit, and I would probably be blushing and batting my eyelashes while I told him all the details. RS, I like the neurosurgeon, probably better for the defense in my opinion, until I found out that he has some horrible Google reviews before the trial. Jury shouldn't find out about that. By the way, Google reviews can tell you a lot. They can help. They can be complete BS in my opinion. Abby Cook, 2.3 miles between, and even good ones can be complete BS. 2.3 miles between 34 Fairview and 1 Meadows, 7 to 8 minute drive in good weather. Yeah, you're not going 2.3 miles based on what everybody's saying in the weather that happened that night. All right, folks, we did it in under an hour and a half today. Closer to our normal time. I appreciate you guys all being here. I appreciate you hitting that like button. We'll see if we can get this one to 30,000 likes. And please make sure you subscribe. Love you all. You're the best. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.